These are just some of the key points of
Okay.
difference, as I assert, between the Indiana law and the original federal law. The original federal law, the big headline is, it was designed to protect religious minorities. You know the background. I don't mean to condescend to you. You know it.
Absolutely.
This one is designed to protect
Absolutely.
Christian businesses, which are a majority effort, not a minority. Substantial burden was the strict scrutiny standard under the federal law. This is burden or likely burden under yours, which makes it a potential injury, not an injury. And then federal laws, of course, about state action, because that was the concern. And you could even extend that to Hobby Lobby, which was state action, mandating a business pay for contraceptives within healthcare. This includes that the government does not have to be an entity. This could be a private party bringing the action. And, of course, the federal law didn't really have to deal with any discrimination because it was dealing with an aggrieved class. Here, you have a class that wants to aggrieve others and say, we find you intolerant, we don't like your beliefs, so we don't want to do it. Those are key distinctions, don't you think?
Well, Chris, you're trying to get me to defend the law.
Yes.
I wasn't the author or the sponsor of it. I did vote for it. And that was, I will tell you that the intent that's being stated was not the intent of those legislators who voted for this. We don't support discrimination. It was not the intent. My focus now is to fix that concern, and we're extremely close to making that happen, to make it very clear that we're not trying to discriminate against any class of Hoosiers, including those that are gays or lesbians.
But the concern is obvious, and now you said, we're in the rethinking phase, and you said during a presser, oh, it is true, currently under Indiana law, you could put a sign in your window that says, no gays allowed, and that would be legal because LGBT isn't a protected class. How can you tolerate that? No pun intended. But how can you allow that to be the presence of Indiana state law? How can you not change that?
Well, first of all, we don't see that happening here in Indiana, but I get that there's concern that it could. So we are having discussions about the future of our civil rights laws here in Indiana. We have just a few weeks left in our session, so it's just not realistic that that major policy leap can happen in those few short weeks. But what can happen is to make it abundantly clear that the law that was adopted doesn't impact the rights of any Hoosier, especially the LGBT community in any way.
All right, and lastly, when you say, hey, this was never the intention, the speculation is that this was the intention because there was politics on the table here. You didn't get the marriage as defined between a man and a woman amendment through, and this was the give back. That this law would be an accommodation to people like you who want to define, under your Constitution, marriage as between a man and a woman. You are pushing that amendment once again for 2016. Is this your gift because you didn't get the amendment you wanted?
Absolutely not. I'll tell you what the real catalyst was here was the Hobby Lobby, a case that legal scholars looked at and said, this would have been decided differently in Indiana, or at least unclearly in Indiana. You can see those legal opinions on our website,
right.
And if you carefully read it, you'll see that was the motivator.